So I understand that many of you are from St. Francis de Sales High School, correct? I am a St. Francis de Sales High School graduate. Toledo, Ohio. 1976. Going back a ways. So, the story that you're about to hear is a very real story. It's a very true story, and it's a story of our American justice system at its worst. And there are parts of it that some would tell you it's the story of our American justice system at its best. I guess it depends on which way you look at it. There was a philosopher that once said this, and it's kind of a striking thing. It's difficult for us to hear this in relation to our own system of laws. But it said, ours is a system where justice is accidental and innocence affords no protection. Ours is a system where justice is accidental and innocence affords no protection. Those are very harsh words. And they're words that should strike at the very core of who we being, because the justice system is not just about the convicted guilty, but it's also about the convicted innocent, and it's also about all of us who never really have any significant interaction with the justice system at all, because it represents who we are as an American people. I started visiting death row at the request of a Carmelite brother in 1996. I didn't really want anything to do with death row or criminal investigations or anything of the sort. But I started visiting death row in 1996 at the request of a Carmelite brother out of Austin, Texas. And he said that the men on death row, the women on death row, really have a need for some kind of connection to the community, some kind of outside companion to journey through the system with them, and ultimately, if necessary, to be with them as they are executed and their lives are taken by the state. And so I visited a guy by the name of Keith Hennis. Keith has been on death row since 1984, I think. It was before you.
No,
Yeah.
after me.
He was after you?
Me.
Okay, so...
Yeah.
Okay. Anyway, for some time. His crime is out of Columbus here. And Keith now has his own execution date of January of 2015. So that date is quickly approaching for Keith. As I was visiting Keith, Keith would introduce me to the guys that were in the cells around him on death row. And back at that point in time, if you were an attorney, you could actually go back onto the pod. You could go back into the cell block and visit with the guys in their actual cells. And so I was visiting in the cells that day, and Keith just introduced me briefly to Joe, who was in the cell next to him. And that was about the end of it. I waved to him and I introduced myself to him. I would see him every now and then playing in the basketball court or behind the glass of behind the guards station in the pod. It wasn't until December of 1998 when Joe's mother, Dorothy, died. And Joe was a Cleveland guy, and I am a Cleveland priest, and I saw his mother's obituary in the newspaper, and so I went to the wake, and then the next day I went to celebrate his mother's funeral, because I knew that death row inmates had no access to funeral services for their deceased relatives. And I thought, well, I'm going to go. And then the next time I'm visiting on the row, maybe the corrections officers will allow me to talk with Joe, even though I wasn't on his visiting list. And so when I went to visit Keith the next time, which was about 2 or 3 weeks after Dorothy D'Ambrosio's death, I ended my visit with Keith early, and I asked the COs if they would bring Joe out so that I could talk him through his mother's death, through the wake, through the funeral service, and kind of bring some closure to him about his mother's death. And I'll let Joe tell you about what that visit looked like for the two of us.
Well, he's sitting there trying to tell me about my mother's death. And I'm trying to sit there and tell him, okay, that's well and fine. She's dead. I'm alive, but they're trying to murder me for something I didn't do. And he kept going back to talking about her funeral. And I'm like, yeah, but help me. Because up to this point, I tried writing everybody. I wrote every journalism school, every law school, every innocent project. I wrote all the media that I could. I even wrote Oprah asking for help. Nobody wanted to help. Nobody. But now I had a human being in front of me, not just a human being, a priest, a registered nurse, and an attorney. He's all three, all wrapped up into one. So I keep sitting there and tell him, listen, you got to help me. I understand about my mother's death. This might be cold, but it's like, she's dead, I'm alive. Help me. And he's like, I just can't. Because most death penalty trials are volumes long in its writing. And he's thinking, and each volume is like 500 pages long. And I'm telling him, no. My trial is the shortest death penalty trial in the state of Ohio. 2 3/4 days from let's start to you die. And he's like, you can't be. No trials are that short. And I'm like, yes, it is. It's only 1 volume long, 462 pages from start to finish. And the attorney in him struck up in him. He's like, this can't be right. So luckily, he took it. I finally talked him into taking it. After I made him swear to bring it back, because it took me over 2 years to get, because my attorneys didn't want to give it to me. So I finally gave it to him, and luckily, he took it home that night.
So I took his trial transcript home. I was a busy priest at a parish. I've seen death penalty transcripts before. They're enormous. They're absolutely enormous, and they're so complicated. But when he told me that his was 1 volume, double-spaced, legal printing, I knew that there was striking in and of itself that somebody in our state could be sentenced to death in such a short period of time. And so I took it home and I read the entire trial transcript that night. And I came to the coroner's testimony, and she was describing the wounds on the deceased. His name was Anthony Clan. He was 19 years old. And Anthony Clan was sliced from ear to ear, huge, gaping wound. And then he was stabbed 3 times in the chest. So they missed the jugular veins and they missed the carotid arteries completely. Completely missed them. And how, I don't know, because the wounds are absolutely atrocious. But what they did do is they opened up 2 large holes in Anthony's trachea, very large holes in Anthony's trachea. And after these holes were created, the coroner testified that Anthony was able to jump down into a creek bed, run away from his attackers, screaming, because this is what they had gotten from a witness, that he was screaming for his life, please don't kill me, please don't kill me. Well, when your airway is compromised with those holes in the trachea, you're not making any noise. If you are cognizant that you have a compromised airway, you might be able to take your finger and plug it, as some trach patients are able to do, but then you might get something that sounds like this. But Anthony didn't know that he had holes there, and he certainly wouldn't know that there were 2 of them there, and he certainly wouldn't know in the midst of this panic that he would do anything of the sort. So Anthony wasn't screaming anything. Subsequently, I went down to the coroner's office and I obtained the autopsy photos and the entire autopsy protocol. And so I determined from that Anthony had 650 milliliters of blood in his trachea. So if Anthony was making any noise, it would have been drowning in his own secretions and gurgling on his own blood, but he certainly wasn't screaming. Absolutely, physiologically impossible. And yet that's what the coroner was testifying to, and none of Joe's attorneys followed that up with any logical sort of questions. And so I knew immediately that at least that part of the testimony was wrong, and I knew immediately that this was just an incredibly short beginning and ending trial. And it started the wheels turning. My gosh, if what Joe is saying is true about these things that I independently verified, what else might be wrong in Joe's case? And and everybody says this. Everybody says, oh, you're the bleeding heart liberal Catholic priest. Okay, you're the bleeding heart liberal Catholic priest. Well, maybe you heard Joe tell you that I'm an attorney. I've got a degree in nursing. I got a degree in public relations and communications, and I've got 2 master's degrees in theology. I'm not stupid. Okay, so trust me, I did not believe the inmate. Okay, I did not believe the inmate right away. But when I began to independently verify the things that he was telling me, and they were matching up, I thought, oh my God, this man is absolutely telling the truth. He's innocent, and he's sitting on death row for a crime he didn't commit. And so I thought, well, my gosh, this is, if these things are wrong, what is else wrong with the case?
And now keep in mind, this was 10 years after the fact.
It's true, 10 years, that's an important point.
That's a big point.
So I decided that the case needed to be investigated. It was never investigated back in 1988, 1989. And I have a letter from the investigating detective that I'm going to share with you in a moment. But it was never investigated back in 1988, 1989. And so I thought, I need to investigate this case myself 10 years, 11 years after the fact. So on one particular day, I took all of the names of the major players in the case. And I wrote them down on a piece of paper, and I went down to the Cuyahoga County Justice Center, and I sat there for an entire day researching the criminal histories and the arrest records and the conviction records of all of the major players in the case. The days of microfiche, if any of you guys remember any of those things. So I sat there.
Ones are looking, what is he talking about?
I sat there at the microfiche reader, going through these cases, case by case by case. And I pulled up Anthony Clan's record. Now, Anthony Clan was the deceased 19-year-old victim. So I wasn't thinking I'm going to find anything in Anthony Clan's file. What would he have in there? He's the guy that is dead now. And I'm going through the microfiche in Anthony Clan's case, and lo and behold, I find out that Anthony Clan, shortly before he was murdered, was witness to a rape. He was witness to a rape. The young man that was raped was a man by the name of Christopher. Christopher was blind, and Christopher has cerebral palsy. Okay? And Christopher was raped, and Anthony Clan witnessed the rape. Now, he witnessed it because he was Christopher's roommate, and he was walking back into the apartment and walked in on the rape, and he allowed that interruption of the rape allowed Christopher to escape. And so Christopher went immediately to the hospital. The hospital did a rape kit. The rape kit still exists today. And then they immediately contacted the police. The police got involved on it right away, and they arrested a man by the name of Paul Lewis. His nickname was Stony.
Which he's had since he was 13.
Paul Stony Lewis was arrested right away. Now, Paul Stony Lewis has a significant drug history, Stony, and
rape.
And a previous rape conviction.
And violence.
So he's indigent, of course. He has no money. And so in May of 1988, Stony Lewis is thrown into the Cuyahoga County Jail. And trial proceedings begin on the rape case. Anthony was called both by the state as a witness and by the defense as a witness. As a matter of fact, other than the victim, Anthony is the only witness called at all. And so the victim, Christopher, gets notice that he must appear in court for a pretrial hearing. And I indicated to you before that Christopher is blind, but legally blind. So Christopher can read if he can get like this. And so he got the notice of the hearing, and he reads it, and he shows up in court on August 11th of 1988, only to be told that the appropriate court date was August 1st of 1988. And so since he missed it, they released Paul Lewis for want of prosecution. But at the same time, they also said, we will, if things go back into order, we can still bring him back and prosecute him again. So Paul Lewis, with a previous rape conviction, multiple drug histories, and violent crime history, is out on the street facing re-prosecution with only one witness to call against him that might put him back in jail for a significant period of time. And that person is Anthony Clan. And Anthony Clan is murdered in late September of 1988. Shortly after the murder, the rape case is totally dismissed. Totally dismissed because now there's no witness. And somebody points their finger at Joe. Does anybody want to guess who pointed their finger at Joe? Stony Lewis. Stony Lewis. And Stoney calls the morgue. Well, tell him about the morgue visit.
Well, the murder happened on Saturday morning, September 23rd, September 24th. It's an ongoing event. That weekend, somebody anonymously calls the morgue and asks if you have a 19-year-old man in the morgue. And does he have these tattoos? And does he have these wounds on him? Well, lo and behold, it was never written of the wounds that Anthony had. So the person at the morgue said, well, can you come down and identify this young man? And he hung up. Now, there's a police report of this anonymous call, and it also says right on the report, Paul Lewis. They wrote, they know who it was, yet they didn't turn this over to me at the time of my trial. He also then later on in the proceedings asked the police, since he was the star witness, to get him out of a DWI, which they also hid from us. So not only did they hide the rape case, but the anonymous phone call and him trying to get them to get him out of a DWI. And that's just the beginning of the things that they withheld from me. 80% of the stuff that freed me was in 3 places: prosecutor's file, police file, and the coroner's file. And it was there all along. And to this day, I still think that they're hiding evidence.
So Paul Lewis points his fingers to Joe. Joe's arrested, thinking that, okay, this trial is going to free him. There's no evidence of his guilt. And many, many years later, in 2000, 2001, I start investigating the case. And we discovered almost immediately, like a cascade, all sorts of evidence that was just, you gotta be kidding. This wasn't given to you? You didn't know about this? You didn't know about this? They had this and you didn't know about it? They had this and you didn't know about it? And it's just a cursory examination or an investigation back in that time by anybody probably would have found this stuff out, we hope. But it wasn't. Here's a, by the way, Eddie Espinoza was arrested with Joe. And Eddie Espinoza he was one of the 2 murderers, Eddie Espinoza and Paul Lewis. And so Eddie Espinoza is arrested at the same time as Joe, and Eddie is just panicky. And so he gives an affidavit that just details everything about this supposed eyewitness to the crime. And the police realize quickly that this isn't going to fit their theory of the crime or their investigation. And so within 48 hours, they returned to Eddie Espinoza and they coached him on another affidavit. We need you to say this. We need you to say this. We need you to say this. We need you to give us this date, and we need you to give us this time. And so Eddie Espinoza, just within 48 hours of his previous affidavit, gives another one that is a 180-degree turn from where he was before. It is completely different. And it paints an entire different day, time, scenario, and everything. Because now they're retrofitting a case to convict somebody who's innocent. I get this letter from a detective, Leo Allen. He was a homicide detective in the Cleveland Police Force at that time. I won't share it all with you, but just some pertinent parts. Mr. Kookoothe, having been raised as a Catholic and spending 12 years in Catholic schools in Cleveland, I was brought up to idolize priests, and I put them on a pedestal. At age 58, I have certainly changed my feelings toward the church and priests, and your naive ramblings about poor innocent Joe are the icing on the cake. You, Mr. Kookoothe, may have sympathy for D'Ambrosio and maybe think he is innocent. I do not. I arrested D'Ambrosio along with my partner. It was I who gathered the evidence against him, and it was I who sat in court with the prosecutor against Joe. After being arrested, Joe had nothing to say at all, no alibi, nothing. Don't you think if a man was innocent and facing the death penalty that he would tell everyone of his whereabouts to clear himself? He couldn't say anything because he didn't know anything, sir. He didn't know anything. And even more than that, Joe did take the stand in his own defense at trial and testified on his own behalf. Not required to do so. A criminal defendant has to say nothing. And if he says nothing, nothing can be held against him in a court of law. The state must prove the case beyond a reasonable doubt. And so he needs to bone up here on the law a little bit. Joe could not do that because of his guilt. If he was innocent, he would have testified on his own behalf. Sir, you just said you were there for every court thing. He did testify on his own behalf. As the arresting and investigating officer, I was a Cleveland police officer for 28 years, 21 as a homicide detective. I think this experience enables me to know who is guilty and who is not by looking at them. A ton of work is done to make sure we prosecute the right people. I take pride in the work I've done. As each year on the force went by, I became more streetwise. In this case, there were 3 suspects, Keenan, D'Ambrosio, and Espinoza, no more, no less, and certainly no one else. What experience do you have investigating murders, Neil? I knew Espinoza was telling the truth. You're the one that made him swear out the second affidavit. Keenan and D'Ambrosio both cut Tony. Instead of investigating on your own, did you think to talk to the assistant prosecuting attorney and the investigating detective to get the facts? Or doesn't that matter to you? The prosecuting attorney and the detectives are the ones who had been hiding the real evidence for over 22 years. I doubt that they were going to start sharing it with me these many years later.
When by law, they're supposed to turn it over to me.
So he goes on, and he talks about that, and he says that the judges found him guilty. Well, yes, sir. 3 common pleas judges, all former prosecutors, found him guilty. 1 common pleas judge, 1 federal district court judge, and 3 federal circuit court judges overturned the case when it came to them for habeas review. So the courts have indeed looked at this case very thoroughly, and the law has spoken on Joe's case at this point in time. But what else was hiding out there? There was the original detectives who found the body. Detectives by the name of Goldstein and Hayes find the body in a creek bed, floating downward, face down. They find the body, and they immediately conclude that he was killed elsewhere, and that after a period of time, he was dragged to the creek bed and thrown in. I described the wounds for you before. There was no sign of a struggle at the creek bed. There was not a drop of blood found on anywhere near the grass, in the soil, in the creek bed at all.
No tire tracks, nothing.
So they concluded that the man was killed elsewhere, and we believe that we know where elsewhere is at.
Now keep in mind, he died approximately Saturday morning at 5 o'clock in the morning. The body was found around noon that same day. So it wasn't like a period of time passed that things could have washed away or the bushes could have filled back up after being trampled down or anything. We're talking a matter of a few hours.
Want to tell them about the clothes?
Then we started to get discovery. The federal judge ordered them 3 separate times to give me discovery because they kept hiding evidence. One of the pieces of evidence was a piece of paper like this, and on it there was a line down the center and a line across the top, and my name and Ed Espinoza's name were on the top. Height, weight, measurements, height, weight, measurements. Now, I'm 6'2", 200 pounds. Ed Espinoza's 5'7", 160 pounds. At the bottom, it said, found bloody clothes in garage. Now, at trial, there was no clothes put into evidence. No clothes were ever found.
Well, they were found.
Well, they were found. They were never brought into trial. They were never submitted into evidence. Reason being, I'm 6'2". Let me try a pair of pants on that a 5'7" guy has. It's going to be an OJ moment. It really is. So they never brought them in.
Which is
And-
significant.
Right. How
Because
would
if they're
bloody
Anthony's
clothes?
blood and they're his clothes, case done.
You know, you might as well just end the trial right then and there. They never came into trial. There was Ms. Farinacci that lived, well, we'll start with the tape. When I was arrested, there was a police informant that was also in the county jail at the same time. He called his handler on the county phone, and they recorded the conversation. The only reason we know of this recording is on one police report. There's two little lines, and it says, Anthony Creamy called, says we have the wrong guys, and that's all there is. So we went back to the judge and said, Your Honor, there's a tape, an audio tape of Anthony Creamy telling the police, we want the tape. Prosecutor stood up and said, we can't find the tape, Your Honor. And the judge asked, well, who was the last to sign it out? Guess who was the last to sign it out? Prosecutor's office. And they can't find it. Around the time we found out this tape is supposed to exist, Anthony Creamy died. So we can't even ask him what he knew, how he knew it, and any of that. On top of that was Ms. Farinacci.
Teresa Farinacci was a woman living in Little Italy in Cleveland at the time. She still lives in the very same home today. Teresa Farinacci is very clear about what day she's talking about because it was her niece's wedding. It was a Friday night wedding. It was her niece that got married, and she went to the wedding. She comes home from the wedding reception in the early hours of Saturday morning. When she arrives home early Saturday morning, she hears this violent altercation in the apartment next to her. So violent that she calls the police. The police respond to her call. When the logs still exist, indicating the police response. They arrive at the neighborhood. By the time they get there, lights are turned out. There's no violence. There's no noise. It would appear like nothing had ever happened. So rather than disturb anybody at 2 o'clock in the morning, they don't knock on the doors. They don't start questioning anybody. And it's like nothing ever happened. The next afternoon, late morning, early afternoon, Teresa Farinacci leaves her home to go do some errands, and as she's walking out of her house, she looks over to the side in front of the next house, and she sees Anthony Clan in the back of a pickup truck. She knows Anthony because her daughter one time went out with Anthony, and so she calls to Anthony Clan, and he does not respond. So she calls out to him a second time. A second time, he does not respond. And she says she thought that he was just sleeping off a drunk. And so she just ignored it. She says now that she wishes she had gone over there to try to talk to him. Anthony obviously was in the back of the pickup truck waiting to be delivered to the creek bed, but he was dead. And in 2009, as the case is being reinvestigated in preparation for a retrial, the federal marshals contact Teresa Farinacci again, and they interview her again, and she tells the same story again. They actually call the niece now to verify that that was her wedding date, and the dates and everything are all lining up. And they said to her, Miss Farinacci, you think you saw Anthony in the back of a pickup truck? And she says to them, you're not hearing what I'm saying. I don't think I saw Anthony in the back of a pickup truck. I saw Anthony in the back of a pickup truck. So she's quite clear that Anthony was in the back of that pickup truck that particular day. There was an elderly couple who lived in the second floor of this apartment building. They are also both deceased now. And they swore out an affidavit when they were later interviewed that they had heard somebody say, we need to dump the body. We need to dump the body. Who lived in the house next door? Stoney Lewis lived in the apartment next door, okay? And so we believe that that is where Anthony was killed. We believe that Paul Lewis and Eddie Espinoza are the actual perpetrators of the murder. This case, the many, many years later, the autopsy was looked at again by a coroner by the name of Werner Spitz. Werner Spitz.
You might remember him. He was in the OJ case.
The OJ case. So he looked at the case many years later, and he indicated that Anthony again, I told you, was found floating like this in the water. But he indicated that it's called Livor Mortis. And he indicated that Anthony had to be laying on his back for at least 45 minutes after he had died. Because livor mortis means that the blood pools to the most dependent portion of the body. And that dependent portion of the body takes on a very red rubric color. And when you look at Anthony's autopsy photos, you can very clearly see that the front part of him is very pale, and the back part is where the blood has pooled and is very red in color. So he indicates that he had to have been dead on his back for at least 45 minutes. And then he indicates that there are some markings on his shoulder that were missed at the time of the original autopsy that are consistent with the body being dragged. And so we believe that all of that's taking place within the context of him being murdered in the house next door, not at a creek bed.
And there's numerous other pieces of evidence. Yeah. We don't have time to go through all of it.
But there is another significant part, is the knives. Yes. When they arrested Joe, they confiscated 3 large hunting knives from his home.
I'm a sportsman.
And they were large knives. And this is one of the reasons why I didn't believe Joe to begin with, right? Because these knives, pictures of the knives are in the coroner's file. And when I saw these knives, I'm like, yeah, what's the possibility of arresting somebody, finding these large knives on their dining room table, and not have the real perpetrator? And of course, in 1988, there was not nuclear or mitochondrial DNA. All there was blood group typing. And so the state sent the knives to their own criminal investigation lab, and the knives came back negative for blood. All 3 of them, no blood on the knives.
But it didn't stop the prosecutor from waving them around all through trial, calling them the murder weapons. One of my knives is 14.5 inches long, 2 3/4 inches wide. It's what they call a gutting knife or gutting deer, because I was a sportsman. That's what you use.
2009, the case is going to retrial again, right? So they take the knives. Now there's mitochondrial and nuclear DNA testing that can be done. So this time they send the state sends the knives to their own criminal investigation lab. This time they don't just test the blades, but they take the leather sheathing apart, and they take scrapings from the leather sheathing. They take the handles off of the blades. They scrape under the handles. They test all of those things. Now there is not only no blood, but there's no DNA of any kind at all. State's lab, state's report. Still, they wave them around as the murder weapons. They wave them around as the murder weapon. Well, long story short, and then we'd like to get to some question and answers and talk to you a little bit. When we discovered the rape case and many of these other things, we were able to put them in front of the federal judge in federal district court. And when she saw it was the rape that really opened her eyes and said, whoa, 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 whoa. But when we put that in front of her, she saw the fact that there was so much wrong with this case that the conviction was not constitutionally sound. And so she ordered a sweeping discovery period where she ordered the police, the coroner, and the prosecutor to give everything, no holds barred, everything to Joe. And then in 2003, the federal court held a hearing on this newly discovered evidence.
3 days long, half a day longer than my trial lasted.
10 years later, a little more than 10 years later. She holds this discovery evidentiary hearing. She determines that the case she reverses his conviction and sentence and orders one of two things. The state can either retry him or release him, and they had 180 days to do that. Well, they put that on hold while the state appealed her decision to the court down in Cincinnati. And the court in Cincinnati agreed with her, and so then the state says, well, we're not going to let him go. We're going to retry him. And so they started all of these proceedings to retry Mr. D'Ambrosio. And the prosecuting office turned that courtroom into a circus. Just one stalling, obfuscating procedure in motion, one right after another. They even tried to have the trial court judge thrown off the case by fabricating a motion with her name on it. That wasn't successful.
They took that all the way to the Ohio Supreme Court and lost.
So we're 1 week before Joe's new trial is to begin.
And right before lunch, the prosecutor stands up and says, Your Honor, we've got a motion we want to file to the court. So they hand the motion to the judge, and it's a motion saying that they have given me every last bit of evidence in this case. Any name that's mentioned in my case, I've got every file of theirs, everything and anything that they can have or that they have in their possession is now in my possession. The judge is like, okay, fine, bangs the gavel, we all go to lunch. We come back from lunch, and the prosecutor's scrambling over by their table, and we're like, what's going on? You know, we're expecting the judge to be like, okay, we're getting ready, trial's gonna be starting here in a week. And all of a sudden they stand up and say, Your Honor, we got something we gotta say. And she's like, yes. And she's like, well, we just found 5 more pieces of evidence in a closet we haven't been in. And the judge is like, what? I thought you just filed a motion with me that I have, that Mr. D'Ambrosio has everything. Not only was it evidence, it was DNA evidence. It was tissue samples, swabs, some soil samples, and a latent boot print off of the door that was, one of the doors that was, a door that was kicked in. Now the trouble comes, because I want this stuff tested. No matter what, I want this stuff tested because I know I didn't do this, and if this stuff can prove my innocence, I want it tested. The only problem with that is it's going to go past the time period. So they argued back and forth and all of that stuff about it, and finally the judge says, no, this stuff will be tested. So the prosecutor, really quick, jumps and runs to the federal judge who gave me the reversal and the 180-day mandate that they must retry me by, and asked for more time. And the judge was like, whoa, wait a minute. You're talking about evidence that you guys were supposed to turn over in 2003 that I ordered you guys to do? You guys are still finding more evidence now? And that's when she started, well, is there any more closets? Is there any more files? Is there any more desks? Is there anywhere that there can be more evidence? And they were swearing up and down, no, there is not, there isn't. So she said, we were asking, we're like, Your Honor, this just shows they're still hiding more evidence. They're still lying, cheating, destroying evidence. Bar his re-prosecution as a punishment for the prosecutor with these ongoing games. And the judge is like, that's going too far. She says, what I will do is I will expunge his record. I will not allow you to retry him under this indictment, but I'm not going to stop you from retrying you. And then that she sent this back. So that meant I had to come back, they had to rearrest me and start all over again. And it was just ridiculous. Now,
They had, so she orders the record expunged and gives them a full writ of habeas corpus, literally, saying that this conviction was not constitutionally sound. But she would not prevent the state from retrying him. And there's no statute of limitations on murder. He can be rearrested, retried. And so that's what they do. They re-indict him, they re-arraign him, and they begin the process again. Only to find out that while this federal judge was sitting in habeas in the federal court, that the only eyewitness, this Eddie Espinoza, died. He died on April 27th of 2009. Now the state knew that he was dead within 2 days of his passing. The state knew that he was dead within 2 days of his passing. And they refused to tell Joe or the defense or the state court or the federal court. They kept that information about his passing to themselves until July of 2009. And in July of 2009, did I get that right?
Yeah, it was July.
Yeah, July of 2009, Joe's attorneys go back to the federal court and said, Your Honor, if you had known this, that this man had died, the only eyewitness upon whom the whole case was built, would you have barred his prosecution then? And she looked at it and she said, yes. Had I known that this was the case, I would have barred his re-prosecution. And then she just chastised the state for hiding this from her. And so she did then. She barred his re-prosecution so that the state could not retry him. They appealed that to the court in Cincinnati. The court in Cincinnati agreed with her that the case should be barred from prosecution. They took that to the United States Supreme Court. The United States Supreme Court refused to hear the state's appeal, which left the Sixth Circuit Court of Appeals opinion intact, thus fully exonerating him on January 23rd of 2012. So he is now the 140th death row exoneree in the country, the 6th from the state of Ohio. He has no arrest record, no conviction, no constitutionally sound procedure was ever held against him, and he enjoys today the full presumption of innocence that he held before Anthony was killed in 1988. So that's where he's at today.
So what happened to me is bad, but what we must always remember is the victim in this case. The kid was only 19, and he lost his life. And this kid will never get any justice because they will not go after the real perpetrators, because by doing so shows they shouldn't have come after me. So Stoney Lewis, to this day, still has his freedom and walking around, and Anthony has no justice for what happened to him.
And before I open this up to questions, I want to let you know that this is a rare story. But lest anyone think that it's a one-off, I have a whole stack of cases here from Ohio where innocent men were convicted and spent serious time, not necessarily on death row, but in prison for crimes they did not commit, and they were ultimately discovered to be innocent. I want to point out two cases, because many of you may be aware that Ohio is currently conducting a study of their death penalty system, and the results of that will be released in the coming months, where they're going to try to fix it. They can't fix it, but they're going to do their best here. There is a case, David Stephan is his name. David Stephan is the longest death row inmate. He was convicted out of Cincinnati in 1981. He's been on the row since 1981. He is out of Cincinnati, Ohio. David was convicted of the rape and murder of a young woman by the name of Karen Range. I will tell you right now, David killed Karen Range. There's no doubt. He confessed. He admitted to killing Karen Range. Okay. He did not rape her. And that's significant because without the rape, he would not have been eligible for the death penalty. The rape murder was the specification that allowed this to be tried as a capital case. So he does admit to the murder, he does not admit to the rape.
Which makes no sense, right? Why would you admit to killing somebody, but you didn't rape her? It's like, really? That makes no sense.
They found out about 2 or 3 years ago, Google it, they found out about 2 or 3 years ago that David was indeed telling the truth. He did not rape Karen Range. Karen Range was raped in the morgue by the morgue worker after she had died. Okay? Come to find out that the Hamilton County morgue worker had raped several bodies while he worked there. So David Stephan should be off death row, and he's not. They're even arguing about whether or not he deserves a retrial at this point. And the morgue worker, I think, has been fined and has served his sentence and is out, I believe. There is another man out of Cleveland. His execution date is May of this year. He will be executed. His name is Arthur Tyler. Arthur Tyler is been there since 1984, convicted of the robbery and murder of a vegetable huckster in Cleveland by the name of Sanders Leach. I will tell you this, that Arthur Tyler is guilty of the robbery of Mr. Sanders Leach. He is not guilty of murdering Mr. Leach. He had a co-defendant by the name of Leroy Head. Leroy Head has testified by affidavit, sworn affidavit, and in oral testimony that he indeed is the shooter, the gunman, in the murder of Sanders Leach. At least 4 times he has testified that Arthur did not kill him, he did. Leroy Head was released from prison in June of 2006, and Arthur will be executed in May. Can you see? I mean, there's just too much wrong here. And these are just, again, these other cases that I have here are not death penalty cases, but there's some famous cases here. And I want to tell you this too, that all along the way, throughout this whole thing, for the 180 days, the state adamantly said to the judge, we are ready to go forward to trial. We are ready for trial, Your Honor. We are ready for trial. We are ready for trial tomorrow. When it came to that day when we were 1 week before the trial was to begin, the common pleas judge asked the state how many witnesses they had subpoenaed, because they had already had a voir dire, a jury pool of over 100 people waiting. So she asked the state to identify for the court at that point in time how many witnesses in this capital proceeding had they subpoenaed for testimony.
Now keep in mind, they gave me a witness list of over 300 people.
Yeah, they throw everybody on a witness list.
They had my dead mother on the witness list.
They had me on the witness list. I didn't even live in Cleveland at the time. They had subpoenaed no one. With 1 week to go in a capital trial, they had subpoenaed not one single person. So that's Joe's case. Let's get to your questions so that you can drill it down to what you want to hear and what you want to know about Joe's case.